From WKNOW, this is Steve Chanley with One Question Too Many. Today's program is made possible by the law firm of Employer Advocates Group, serving California employers since 2002, with offices in Orange County and San Luis Obispo County, California. eaglawgroup.com. We're joined today by Thomas Murphy, a sitting trial court judge for the 5th Judicial District in Iowa. He was appointed to the bench by Governor Kim Reynolds in 2017. Welcome, Judge Murphy, and thank you for being with us today.
Thank you for having me.
How long did you practice law before you were appointed to the bench?
25 years.
What was the nature of your private practice?
For 15 to 16 years before I went on the bench, I had a general civil practice. I might work on an ERISA case one day, try a divorce case the next day, and then work in construction litigation for the rest of the week.
That's quite a swath of territory to cover in a practice.
It was.
Was criminal defense a part of your practice at that time?
No, I was involved in 2 criminal cases. I talked to my partners about some of theirs, but I never tried a criminal case.
But you tried a lot of cases before you took the bench?
I did a number of jury trials, mostly personal injury, medical malpractice, and things like that, but not a lot, less than a dozen, I think.
Did the opportunity to serve the public play a role in your decision to accept the appointment to the bench?
It did. I was always serving on boards, volunteering for things, and I had in the back of my mind that I wanted to be back in public service.
We spoke offline about the fact that you also served in the military. So as a citizen, I thank you for that service.
You are worth it.
Is serving the public something that's one of your core values?
I think so. I think it was instilled by my parents and the community in which I grew up.
As a trial court judge in Iowa, you don't have judicial assistants or law clerks, paralegals, or secretaries. How hard was it to adjust to not have those resources once you took the bench?
It wasn't that hard for me. And I knew when I interviewed for the judgeship that one of the things that was being considered was whether a person could do more with less. I always had one paralegal / secretary and worked with that person only. I did most of my own writing. And when you go on the bench, you don't have to go find witnesses, organize bankers' boxes, or I guess now electronic files of documents. So it wasn't that hard of a transition for me for the workload in doing the work.
You currently preside over both criminal and civil cases?
Yes.
Did you receive training through the Iowa Judicial Branch on presiding over criminal matters?
No, we're doing a better job of that in our subdistrict. But I came on the bench the last few days of December of 2017, and in February of 2018, I was trying a sexual abuse case. It was a little bit, it's on-the-job training.
That seems like quite a challenge to pick that up if up to that point you've done nothing but civil law.
It was a challenge. I have good colleagues who I could call and did throughout that trial. The jury instructions are all stock, but it was interesting. I had a lot to learn very quickly.
So what were the primary differences that you saw in presiding over criminal cases?
The lawyers in criminal cases, wise, of course, the number of jurors, the speed at which things generally get to trial, the amount of discovery, things like that are all different. But the lawyers in criminal cases, the ones who try a lot of cases, are really, really good by and large. They're on the ball on rules of evidence. They're efficient. They don't waste any time, and they really know how to present a case and tell a story.
So I have to ask, what was it like the first time that you took the bench wearing a robe and wielding the gavel?
It was humbling and somewhat terrifying, to be honest. It's a completely different ball game. No matter how many times I'd been in court, I really wasn't ready for I don't know if ready is the right word, but it was just so unique and different being there. It was very humbling, and it felt like I had a tremendous amount of responsibility, even though I'd signed up for all of that.
But you felt the weight of the moment at that time.
I sure did. I would say to someone who wants to be a judge, you have to be willing to accept that that robe is very, very heavy because it carries a lot of responsibility.
I'm going to ask you some questions about jury trials and juries now. How important are a jury's first impressions of a party on the outcome of the trial?
I think they're important, but if it's a bad first impression, I don't think it's fatal. I think juries really want to do the right thing, and they take service seriously, and they really follow the instructions.
How important is it for trial counsel to be perceived as likable by a jury?
Likable's nice, but trustworthy, efficient, and competent are more important. Not every juror is going to like every lawyer, but they expect professionalism and candor.
How do most juries react when counsel is overly aggressive to a witness on cross-examination, for example?
I think it depends on the witness, but by and large, juries don't like excessive browbeating. It's unnecessary in most cases, and it usually backfires.
Is that, in your experience, a persuasive technique in any way?
Only when someone is clearly not telling the truth, a witness, when what the witness is saying is inconsistent with prior statements or inconsistent with documentary evidence. I think sometimes, or the witness is arrogant, sometimes juries don't mind a little bit of a beating, if that makes sense.
Kind of give the witness their comeuppance.
Right.
So in that scenario, the examining attorney is sort of the surrogate for the jury, I would imagine.
Yes.
So I have to ask you this question too. How do you handle it when potential jurors try to get out of serving on a jury?
I try to nip it in the bud, not to thank me for my service guy, but I tell jurors that I served in the military and that I think jury service, and I mean this, is as important to the support and defense of the Constitution as is military service. So I lead off with that in the first few moments of meeting the panel. That sets the tone. Then I tell jurors that they're only excused for non-refundable plane tickets, surgeries that cannot be rescheduled, and deaths in the immediate family. And I tell the lawyers to stay away from open questions like, is there anyone here who can't serve on this jury for a week? Because, as you know, jurors will drop like dominoes. If one juror gets out for a work-related reason, then everybody has a work-related reason. But I think jury service is important, and I challenge people to be there. For the people who are really trying to get off of jury duty, I learned from a colleague that if they're struck for cause, they stay in the room until everybody's done and the jury is selected. And the first, if a person's really trying to get off and gets off, the rest of the panel sees that person staying and knows that they're going to be there all day no matter what.
I have little sympathy personally for people who intentionally try to get out of the responsibility of serving as a juror. And I've actually told people quite bluntly, if you don't want to serve on a jury, then you shouldn't complain about the criminal conduct that happens in your community.
Exactly. I've seen jurors or the panel engage in sort of a murmur when someone's trying a little too hard to not serve. And I think the mood in the room changes and people realize it's not good to try to get out and your fellow citizens don't like you for it. And so I really haven't had that be a problem very much. You know, every couple of cases, there's someone who tries pretty darn hard not to serve. Funny story. I had one of my early cases. I've had 47 jury trials as a judge. A juror showed up on the morning of jury selection wearing a Cheech and Chong t-shirt. And I just looked at him and smiled and said, sir, you know, this is a civil case. And he looked back and laughed and said, okay. We kept going.
Let's talk a little bit about the process of picking a jury for a trial. And so for our listeners, can you explain the whole process of voir dire?
Sure. Voir dire is the opportunity for attorneys to figure out if jurors have any bias, any relations to any parties, any preconceived notions about types of cases and things of that nature. It's also the attorney's opportunity to lay a little bit of groundwork about who they are and what the case is about. We tell attorneys that they're not allowed to try the case in voir dire, but most of them do a little bit of it, and the other side allows it because they want to try the case in voir dire as well. But it's a question and answer session with attorneys and jurors to establish concepts, to see if any juror has any bias, and to really engage people to see who would be a good fit to serve on any particular jury.
Is there any other phase of a jury trial where there can be that direct interaction between the attorneys and the jury?
Really only openings and closings, not questions and answers per se.
So in that sense, the voir dire process is very unique in that there's the opportunity for two-way communication.
Yes, I think it's really unique. And I think it's a good system. I enjoy watching it. I enjoy watching good lawyers do voir dire. And there are really good lawyers who have unique questions. And I always take note of someone who does something unique, still coloring within the lines, to get good information out of jurors about whether they may have a bias or sometimes even where they lean politically or things like that may come into play, for example, in a civil case.
Can you tell us a little bit about the concept of primacy and how that might factor into the voir dire process? Just the concept that some people will believe something because the first thing that they heard about it was X. And then the bookend to that is recency. So they would believe the last thing that they heard about something. So the idea of primacy is to plant the seed on the front end. So in practice, how do you see that play out?
I think good lawyers try to plant those seeds, and I think they're fairly effective at it. Some lawyers will say they win or lose a case in voir dire. I don't agree. I think jurors, if the judges challenge them correctly and the trial proceeds efficiently and all the right evidence comes in and none of the bad evidence comes in, I think jurors try to keep an open mind and follow the instructions. And they know that the lawyers are trying to plant some seeds, but they're going to listen to the evidence, review the evidence, and listen to the testimony.
In higher stakes litigation, it's not uncommon for law firms to sometimes retain experts to aid them in jury selection. In the real world, do you think that ultimately makes a difference on the outcome of a trial?
Honestly, I don't know, Steve. I've had one trial where I suspect there was some of that, but I don't think it would have made a difference in that case.
I have to say that I've heard some people say that's just voodoo and it doesn't really make a difference. But it's interesting. Some people have very hard and fast rules on using a consultant to pick a jury.
I think a consultant might be more effective in coaching the lawyer about the questions to ask jurors, because that's important. And perhaps if some expert has done, for example, a study of a focus group has engaged in some voir dire and then reviewed a case, and based upon the focus group's answers to questions, maybe then, but I just don't know enough about it. If in terms of body language and things like that, that to me is kind of voodoo. I have 3 children. 2 of them can confidently look me in the eye and probably not give me the right story. The other one's a little timid and would always tell the truth, but maybe not look me in the eye. Does that make sense?
Yes, that makes perfect sense. This is somewhat off topic, but with the advent of artificial intelligence and its ability to engage in, deep thinking that is designed to emulate human thinking, I wonder whether at some point AI might be used to develop a profile of an ideal juror in a particular case. Do you think, can you envision that?
From what little I know about AI, I think I can envision that. If it's probably a combination of statistics and experience. I don't know how that information gets loaded into a system, though.
Interesting to consider the various ways that in the future AI will permeate the criminal and civil justice systems, but probably more so in the civil arena.
I think we'll see more of it. There's a prominent lawyer in Iowa, well-respected and good lawyer, who's using AI to assist in trial prep. For example, he said that he gives the program certain information and asks the program to write an opening statement. And it does, and then he rewrites it in his style and adds and subtracts things he wants to. So they're already using it. I, fortunately, to the best of my knowledge, haven't had anyone cite a made-up or an AI made-up case. I hope I don't, but it's happening.
There have been some very well-publicized examples of that, but I'm wondering whether demonstrative evidence, for example, at trial, what kind of utility AI will ultimately have. Do you have any thoughts or experience on that?
I think it could be great for the lawyers and for the parties. I assume there would be some evidentiary fights, even over demonstratives, for probative value versus prejudice. But what a tool that's available now to do that kind of stuff. Probably save money on the firms who've been developing things for lawyers.
It's at the point now where AI can create very realistic 3D models of things. And it would seem that if the underlying information can be authenticated by a witness, that the model or the image could be very helpful to a jury in trying to discern what actually happened in a particular case.
Absolutely. I'm envisioning line of sight within buildings or traffic situations, things of that nature. I think it could be a very useful tool.
I think at some point, the codified rules of evidence, both at the state and federal levels, will have to make accommodation for the use of some of these technologies. I asked a guest recently what their opinion was on the potential of attorneys in a trial court setting using deep fake AI as part of their case. So deep fake is a term that they use when the AI technology is so good that it can replicate what someone's face looks like. And so through manipulation of an image, they will put somebody's face on somebody else's body who's doing something. So for example, if there were video of somebody committing a crime and they used AI to create someone else's face on that person, at some point, the technology is going to get so good that it's going to be very, very difficult to tell whether or not it's authentic or not.
Now that you mention it, I remember having lunch with one of my colleagues, well, several of my colleagues, I think, in the last few months where someone brought that up. And I think the rest of us just sort of shuddered at the thought of it happening. But that could really happen. And we'll have to watch for it.
Let me change gears here a little bit. You posted on LinkedIn some time ago some advice for the attorneys who appear in your courtroom. And one of the pieces of advice was to avoid using complicated words and to communicate in plain language. How do you think that's perceived by most juries, the type of vocabulary that trial lawyer uses?
I don't think juries are impressed by it. I've had juries tell me after trials that one lawyer in that trial, this happened several times, was overly impressed with the lawyer. Or this is, I think, a quote from a juror: "No one likes the person who thinks that person is the smartest person in the room." That doesn't affect the outcome of the case, because in that case, that lawyer's client prevailed and did well. But if you don't have to annoy someone, then don't, right? Now, not everyone will be annoyed by, an outstanding vocabulary, but if it's perceived as pomposity, it just makes the experience a little less exciting for everyone else.
You could also see it being contraindicated to the objective of just being an effective advocate, that your use of words can be alienating to juries. Is that a fair statement?
Yes. I had a college professor who made a derogatory comment about military folks or the quality of the average enlistee in the military in the early 80s. And the comment was based upon the United States Army producing M1 tank manuals that were written to a 7th grade level. And I thought the professor was missing the point. There's a genius to being able to write manual for something complex at a 7th grade level. That doesn't mean every soldier has a 7th grade level. It means that they'll spend less time trying to figure things out when they use that manual. Does that make sense?
Makes perfect sense.
I promised a friend of mine I'd mention this. So on the side, I take a songwriting class from a dear friend named Craig Carruthers. I have no financial interest in this, but he's the best songwriter you've never heard of. And he preaches simplicity and brevity. And I thought about that before our discussion today. And I thought about some of the songs, Steve, that you and I grew up with. For example, Carole King's Tapestry. Her lyrics are short and sweet and very emotive, and we get a great message in 3 minutes of song. Great novellas, for example, short stories. The short ones that are easy to read are the ones we remember. And I think there's something to be learned from that for lawyers.
I agree. I think Ernest Hemingway would have been a very effective attorney.
I agree. I tell my kids if they want to be effective communicators, they should go back and read Shel Silverstein. I think it's The Giving Tree.
You believe that most jurors resent it when a trial attorney takes far more time than they should when they're presenting their case?
I think all jurors resent it.
Why is it, do you think, that point is lost on so many attorneys?
I think in law school, we take tests where every issue in one question, or that could be put into one question, is put into that question. And when we argue something as young lawyers, we're afraid that if we don't cover everything, the judge won't get it or the jury won't get it. And I think as we grow more experienced, we have more cases and we have families and we have more to do, we learn to be efficient, and we learn that less is often more, and we learn to let things breathe a little bit.
Harkening back to the advice that you gave on LinkedIn, you had as one of your points, don't bury your lead. Can you explain that a little bit?
Sure.
It ties right into what you were talking about. That's why I raised that.
I think as lawyers, sometimes we present too many issues. We overwrite things. We love the semicolon. We maybe put our main point in a dark heading to a section of a brief, and then we go into long descriptions of cases and outcomes instead of citing quickly to the rule that the case establishes and then saying why our case is covered by that rule. We say in 10 pages what we could say in 2, but when we say it in 10 pages, our message gets lost.
I think you hit the nail on the head that from our early training as law students, there's a fear of missing a point that might be the hook on which the judge may hang their hat. And that results in a lot of excess. And the counterpoint to that, of course, is that they dilute their good arguments by interlarding their brief with weak arguments. Would you agree with that?
Absolutely agree. And I just pulled up the comment of don't bury your lead. And there were subparts to that. And I tell lawyers, describe what you want me to do. Briefly tell me why I should do it. And then remind me of what you want me to do. That's an effective brief. Don't go into the other side's arguments that the other side hasn't made yet. Don't attack the other side. Tell me why your case is really good. Don't attack the other lawyer. Don't attack the other party, unless the other party's committed fraud or something like that. But pick the winners. Just pick the most important points and stick to them. If you're following tangents or every red herring, I will get lost reading your brief, or the jury will get lost listening to your argument.
I can recommend to any attorney out there to read Judge Murphy's 2-page posting on his LinkedIn page, because it's there's not a point on there that's not worthwhile. It is itself a model of why brevity in writing can be so persuasive and powerful. It occurred to me that should attorneys take your advice to heart, it would actually make them much more persuasive in their presentations in the courtroom.
I appreciate that. And so, I think my first draft of this was 5 pages, and so I practice what I preach.
Is it your practice to permit the jury to submit questions to you to be posed to the witness?
I'm glad you asked that. So I started an employment law trial, January 6th, and one of the lawyers asked me to do that. I've never done it. The other side objected. I suspect in that case, they were all great lawyers, but it was the case had gone on too long, and I think they would have objected to each other's mothers attending trial at some point. It was just at that point. They were all great lawyers. I didn't allow it, but I talked to the lawyers on both sides together at length, and apparently it happens a lot. And so I need to look into it. I'm not unwilling to allow it, but I really need to explore it more.
Have you had any cases where that may have made a difference?
Maybe criminal cases. When I talk to the jurors, and I talk to them in about 90% of the cases, when I talk to jurors after the case, often what they want to know or what they wanted to know was really inadmissible. And so I can't say that allowing questions in the cases where I've been asked questions like that would have made a difference.
Sometimes preside over cases where one of the litigants...
Bench trials. I haven't had a jury trial yet where that's happened. My colleagues have. They go not well by and large.
So in that context, do you sometimes ask questions of the witness if your feeling is that maybe the pro se litigant didn't do a good enough job?
Only in equity cases, and those are usually family law cases involving children. But I can say that in most of the family law cases, and that's mostly where it occurs, I've had that involve pro se litigants. The litigants do an okay job. It forces them to set aside some emotion and to be a little more objective in their questions. And we remind them in almost every case, because it sometimes turns into an argument between soon-to-be ex-spouses, that they have to ask questions and elicit facts. Most of the time they get it, and they do an okay job.
Do you think it's a mistake by some trial counsel to make too many objections?
Yes, because eventually jurors figure out what objections are just obstreperous, and there I go using a big word, but versus necessary. I think jurors have a sense of what too many are. I don't always know what they are, but jurors do. We always give an instruction, though, that says that attorneys have an obligation to object and that objection should not be held against them.
Does it sometimes happen that an attorney just stands up without saying anything, but you already anticipate what that's going to be and you rule it?
Not in a jury trial, but it's happened in family law trials. I haven't had it happen in a jury trial. Sometimes the lawyer just says, Your Honor, and it's rhetorical at that point.
Right. I've heard attorneys discuss that, where they're sensitive to the fact that they don't want to give the impression that they're trying to impede the testimony that might be harmful to their side. So if there's some way they can invoke the objection without actually saying it, that they get the benefit of it without the annoyance or the negative downside. So I've always been curious about how judges perceive that.
I think a good way to deal with that is to politely ask the judge for a sidebar. And I usually take attorneys into chambers and we discuss what the objection would be. And then I offer everybody the opportunity to make a record. Sometimes it gets resolved without a record, but I want to make sure that everybody has it. And I think that's a good way to handle it. If it's a polite request and we all come out and nobody looks like they had their feelings hurt, I think the jury's okay with that. Speaking of that, may I revisit the first criminal case question? There were 3 lawyers in that case, 2 very experienced lawyers, one of whom I kind of knew, and the prosecutor I kind of knew. The defense lawyer has a tremendous reputation, just a fantastic lawyer. And then a young person with the senior state prosecutor. I called them into chambers when I knew that I had the case, and I said, I have never done a criminal case as a lawyer or a judge. You have to be comfortable not letting me screw this up for you. And the 2 older lawyers understood that and were very helpful to me and did not take advantage of it. And I don't know this, but I sensed the younger lawyer saw that as odd or a weakness. But I think it bought me credibility with the 2 senior lawyers, and they helped me through the case. They abided by my decisions. They were respectful, but I approached it as a team issue, and I am grateful to them, and I think they were grateful to me by the end of the trial.
Glad that you went back and answered that question. That's a very poignant response.
I appreciate that. But there's a book coming out probably this month called The Book of Judges. A local lawyer solicited essays from judges, I think mostly in Iowa, but federal and state judges, about what judging is about. It's supposed to be for people who are aspiring to be judges or judges who want to see what their colleagues think. And my topic was what makes a good colleague. And if I don't lead with it, I get to it pretty quickly. Humility. I think we have to be humble enough, especially where I work. We drink from fire hoses. We see so many different issues that we know that we don't know everything and cannot know everything.
I sometimes think that the best advice that I sometimes give a client or my response is, I don't know, if they ask a question. I think clients really appreciate that when you have the candor to say, I don't know. I'll have to research that.
They very much appreciate it. And we've all seen lawyers guess, and it doesn't go well for them or their clients. I had a blog before I went on the bench called Bovine Waste Aesthetics. When people would ask, I never want to say I'm the lawyer. When they really pressure me to say, what do you do for a living? I'd say I'm in bovine waste aesthetics. And they got a kick out of that. It got me a lot more bona fides than saying I'm a lawyer.
Yeah, it's funny how people have preconceptions of what a lawyer is or how they should act. Or I seldom volunteer that I'm an attorney when I interact with people because I want them to form an opinion of who I am just based on how I act, not what I do for a living. I'm not a plumber. I'm not an electrician. I can't do what they do. This is just what I do for work. So I always try to downplay it.
I learned I had 2 lieutenant colonels in the Army I worked for. One was screaming all the time. And, if he would, I think he woke up in the morning and reminded himself that he was a lieutenant colonel in the Army. And the other guy was like a monk, and he was so nice and so humble. And every soldier in that battalion would have followed him to hell and back because he inspired, he didn't require. Does that make sense?
Yes, absolutely.
I think I'd rather be judged on who I am long before anybody figures out what I do.
So we've reached that point in our show where I have to ask you, have you ever seen attorneys in your courtroom ask that one question too many?
Often. But let me preface that by saying I want to go back before I die and try a case and not ask these questions. Impeachment is a big one. So many lawyers over impeach. Once they get a contradictory statement from a deposition, there's blood in the water, and they say, okay, were you lying then or were you lying now? And then the witness gets to explain or backpedal. If you say, sir, you just told me X, and in your deposition you said Y, correct? Yes. That's when the lawyer stops. But we all want to say, you lying then or you lying now? Or why is it different now than it was then? And that's the question too many. Good impeachment. The jurors know when they've heard an inconsistency. So I hear that a lot. And then the other one is a difficult witness. We all want the answer we want, and we keep asking the question, and the witness isn't giving us the answer we want. Some lawyers even say, Judge, will you instruct the witness to answer the question? And I always say, the jury heard the witness's answer to your question. What we learn is that sometimes evasiveness is almost better than a lie. It destroys credibility of the witnesses when they argue with you over something simple. And you don't need the answer to the question if the witness is not answering the question deliberately. The jury sees that. So just move on and let them not answer another question.
Judge Murphy, it's been a pleasure and an honor to have you on our show. It's such a privilege to have a sitting trial court judge not only participate, but participate in a very genuine and candid way. So I thank you for that. Is it okay if some of our listeners reach out to you on LinkedIn?
Absolutely.
Can you tell them how to do that?
Sure. I think it's under Thomas Murphy, Iowa District Court Judge, or Iowa Judicial Branch, I think is where it is, Iowa Judicial Branch. I'm connected with lawyers in Iowa who I've never met. We're not friends. We don't socialize, but I enjoy lawyers and I enjoy the practice of law. I think there's great information on LinkedIn. I'm very honored to be a part of this. It's a great.
It's been a joy.